It's 9:33 and we're convening today's hearing. We would like to recess just for a few minutes, perhaps 10 minutes. We'll go off the record until 9:43 a.m. and then we will then convene to commence today's hearing. So we're off the record for 10 minutes. So Dave, we won't take the full 10 minutes. We'll just come back around 9, 9:38 or so.
Okay. I'll stop it at 9:38.
Okay, perfect.
Thank you.
All right, it's 9:38 a.m. We're back on the record. All right, let the record reflect that Dr. Abraham is attending via Zoom. And Dr.
Hi,
Abraham,
everyone.
all right, I'm very confident that that meeting was properly posted and that if individuals of the public are desirous of participating, they can do so. Is that
Absolutely.
accurate?
Thank you.
Thank you. Thank you very
Correct.
kindly, sir. All right, we have one hearing before the hearing board today, which is Energy Holdings, case number 6248-2, facility ID number 186899. At this time, we will ask the clerk if there are any individuals desires of providing non-evidentiary public comment. Do we see anyone signed up?
No, no one signed up either in person or online.
Okay, let the record reflect that no one has sought recognition in person and or online to provide any non-evidentiary public comments with respect to this matter. Madam Clerk, has any individual signed up to provide evidentiary public testimony in this matter?
No, neither in person or online.
All right, let the record reflect that no one has signed up online and or in person to provide evidentiary public testimony relative to this matter. I'm going to turn the floor over to Ms. Manwaring.
Good morning, Chair Ali, members of the board, Mr. Munoz. It's Karen Manwaring representing the executive officer.
Thank you. And who do we have representing Energy Holdings?
Mr. Chairman, my name is Michael Munoz. I am the compliance officer for Inari Light Hype 6 Ice Gen.
Spell the last name?
Munoz, sir.
All right, and you're the compliance officer.
Yes, sir.
All right. Let the record reflect that we have two exhibits before the hearing board. These exhibits have been filed and are online. Exhibit 1, which is the notice of violation. The notice of violation was issued to Energy Holdings LLC, 1717 South Central Avenue, 17171 South Central Avenue, Carson, California on 11219. That's the document before us. And then there's a second exhibit, which is titled Approved List Sorted by Method, dated 8/13/2024, which is Exhibit 2. All right. I believe you're the...
Mr.
No,
Munoz is
that's
the
right.
petitioner.
Mr. Munoz is the petitioner. Okay, sir. Floor is yours to provide your opening statements.
Sir, are we
Thank you,
going to
Ms.
administer the oath since there's no other witnesses for the
Oh,
facility?
so you would be testifying?
Yes, sir.
Okay, okay, gotcha. All right, very well. Okay. So we'll administer the oath. And so how many witnesses do you have, Ms. Manwaring?
This is a variance petition, so the burden is on petitioner. If the board desires to hear from the district, we have 3 potential witnesses, including Mr. Ryan Maxwell, who's appearing remotely today.
Okay, and then you're, Mr. Munoz, you're the only witness. So we will just take a blanket oath for everybody, all right? If you stand, please. I guess you can remain sitting, Mr. Maxwell. You can just raise your right hand, Mr. Maxwell. All right. All right. Do you solemnly state under the penalty of perjury that the evidence that you shall give in this matter shall be the truth, the whole truth, and nothing but the truth? All right. The record is good that all individuals have accepted the oath. Thank you very kindly. Mr. Munoz, the floor is yours, sir.
Thank you, Mr. Chairman, members of the board, clerk, esteemed council, and Mr. Lee and Ms. Abrazizi for hearing my petition today. We are federally regulated public utility providing energy to the Western Energy Cooperative Group. We are regulated by 22 local, state, and federal agencies. Among them include the Department of Energy, the Federal Energy Regulatory Commission, the National Energy Regulatory Commission, the California Public Utilities Commission, the California Energy Commission, the California Independent Systems Operator, and the Air Quality Management District, South Coast Air Quality Management District. Sometimes the regulations or permits are in conflict with each other, and that's the situation that we find ourselves in today. Our permit is a reclaim Title V permit, and under Rule 212, Attachment C, we're required to test our emissions once every 6 months for NOx and ammonia slip. We last conducted that test on 27 February 2024, and we were scheduled for another test on the 18th of September 2024. On the 28th of August 2024, the California Independent Systems Operator ordered IceGen to produce electricity for the California grid, which we complied with. During that run, we experienced a gas turbine trip, and the power plant was powered down under emergency protocols safely. When we started investigating the issue, we found that we had suffered damage from a electricity spike from the Southern California Edison substation called NOLA. And when we further looked at issues at the plant, we found fiberglass insulation in our gas turbine generator filtering mechanism. That entailed that we remove a component of the gas turbine generator, which we did, and we found that our exciter rotor had a ground fault. We removed the components and we sent them to depot about 10 days ago, and the depot is the Electric Machinery's depot in Pensacola, Florida. Those parts arrived today, and so we don't have a timeline of when they will be available back to us. We think that the typical timeline for those components, if we can get parts, are 2 to 4 months. We're currently in an emergency outage with the California Independent Systems Operator, so we are not on the rolls to generate electricity until we commission our repaired exciter rotor. For IceGen, the situation is that once we commission, we go back on the rolls to generate electricity, and we can be ordered by the California ISO to produce electricity. And if we go back online sometime in December, we will be capable of generating power through the 1st of March. On the 1st of March, we'll go back into an outage that has been scheduled for 2 years with the ISO and with General Electric, where we're going to remove our gas turbine and retrofit it to be able to burn hydrogen as well as methane. So we've got a bookend of an outage that will occur in March 2025, and we've got an unknown timeline for the repairs on the current gas turbine generator. So Rule 212 Attachment C allows for 14 starts of the gas turbine after it's been commissioned back to run. We know that we're going to consume 2 of those starts during commissioning. So we have 12 opportunities to run before we're in violation of our permit. In 2019, we violated our permit in a similar manner. We were required to produce power 15 times before we could complete our RADA. The RADA testing for us must be conducted by an AQMD approved vendor, and that AQMD approved vendor must use method 100.1. And so Exhibit 2 shows the vendors that are on the list for providing that service to IceGen. If you remove the duplicates and you remove the people who are no longer in business with the California Secretary of State, you have 6 potential firms. When we call those firms and we ask, what's your lead time for conducting a RADA? The answer is inevitably, it depends. It depends on what time of year, it depends on what their lead time is, and they don't know. Our historical experience is that we can never schedule a RADA for anything less than 2 months, which is why we had scheduled one for the 18th of September previously. So what could potentially happen and what we're concerned about happening is that the ISO will require us to run in excess of 12 days before we're able to complete a RADA because of the lead time. And we don't know the schedule because we don't know when we're going to go back online after commissioning, and we don't know what the weather is going to whether the weather is going to cause the ISO to dispatch us. We were in a similar situation in 2019, and we received the notice of violation, which is Exhibit 1 in front of you. And when we were issued that notice, the Enforcement Division of AQMD said, you should have gone to the board and requested a variance. And one of their points was that the variance for us, there's no excess emissions and there's no risk to the public. It's simply a rule-based issue. And so there isn't any reason not to do it, which was their point to us in 2019. And so we heeded that lesson, and I appear before you today to get in front of this issue instead of, again, receiving a notice of violation. Thank you, Mr. Chairman.
Thank you.
Again, good morning, Chair Ali, members of the board. As this is an interim variance request, so the proceedings will be bifurcated. The district has no objection to a finding of good cause to proceed to the merits. However, when we do get to the merits, the district will oppose the requested variance. Based on the information we know after reviewing the petition, exchanging emails from Mr. Munoz, and a few phone calls I had with Mr. Munoz, the potential violation is far too speculative for this board to make the first finding. As you just heard him testify, it likely will, it may. They will have 12 days, and these are operation days, and they're not necessarily consecutive. So we don't think that Mr. Munoz is going to be able to make the first finding. The violation that he speaks of is far too speculative. Also, the second finding is going to be challenging for Mr. Munoz beyond his reasonable control. My understanding is that he could schedule the RADA anytime before the 12th call-up, as he just testified, but he doesn't desire to run a RADA if CalOCL hasn't called him up because he doesn't make his break-even point. That's what he shared with me. In addition to not being able to make the first and second findings, I'd like to refer to what has been introduced as Exhibit 2, and this should be introduced into the record as evidence after he states it's a true and correct copy. And drawing your attention to the 5th citation there, we intend on questioning Mr. Munoz on the nature of that violation. What we anticipate hearing is that the 15th call day that put him into violation, the 15 days occurred over the months of February and July. So he had 5.5 months to schedule the RADA test before ending up in this violation. So for those reasons, the evidence or the information in the petition, the opening statement that was just made, we do not anticipate that Mr. Munoz will be able to make the first or second finding when we get to the merits.
So just out of curiosity, Ms. Milburn, you mentioned emails and what have you. Would it be out of the ordinary for those emails to be entered into the record as exhibits so that we can understand exactly what you're referencing by way of communication between you and the petitioner?
If you desire to have the email introduced in the record, we can certainly do that. Or in my opening statement, I could simply say, my email drew Mr. Munoz's attention to Rule 2012, Attachment C, B2C, which is an automatic extension of the RADA. And when Mr. Maxwell testifies, he will testify as to the many off-ramps the district rule writers have worked hard to create over the years to prevent a type of petition like we have here today.
Yeah, we'd love to see those emails at a subsequent moment to be introduced. I'm not for sure if any of the members of the board would have comment with respect to that, but since it was introduced and brought up, I would love to see the communication to understand exactly his train of thought. But again, I do welcome the testimony. Mr. Munoz, the floor is yours, sir. You're essentially going to be questioning yourself, I assume. You're calling your witness, which is you.
Mr. Chairman, I guess I don't understand what my testimony, am I going to be testifying?
So there'll be questions back and forth between the district as well as members of the hearing board. There'll be questions that they will ask you. So perhaps if there's anything in addition you'd like to share at this moment in time, and then there's probably tons of questions for which individuals would have, Mr.
Maybe I think we should clarify. I think Ms. Manwaring said this is bifurcated.
Yes.
And we stick to the first part to face the good cause
Right.
phase and to make the case for good cause. I don't know if you have it in front of you or you're familiar with the process for good cause.
I have the bullet points that indicate what I am required to prove, starting with that the petitioner for a variance is or will be in violation of section 4170 or of any other rule, regulation, or order of the district. Is that what you're referring to?
Yes. So I think we go step by step. So you have to make your case for good cause to the board. And then once the board votes on whether we find good cause, then we go to the merits of the interim variance. So if you can stick to that portion first.
The good cause portion.
Yes.
Cause portion initially, and then we can proceed.
So then this is the document he's referencing. So perhaps you just kind of walk down and answer, or at least provide commentary to these statements.
Sure. So I read the first one out. And so our issue is that council just said that we don't want to perform the RADA because we don't hit our break-even point. That's actually true in that we're a commercial business and we're likely to lose about $40,000 on a run if we run in Q1 of 2025. But that's not the overriding issue. The overriding issue is timing. We will potentially come back online sometime in January in a best case scenario. And in January, if we schedule a RADA, again, our history is that we have to schedule 2 months in advance. And we won't get to that post-commissioning 2 months timeframe before we go back into outage on the 1st of March. So it's a timing issue based on our historical experience. And I even heard the other side say that, oh, well, you can get it done in 2 weeks or 3 weeks or 4 weeks. We know what historically has happened for us. There's only 6 vendors for all of AQMD that can sample with method 100.1. And so we think there's a real possibility that we're going to exceed the 12 additional starts after the 2 that we consume for commissioning, and that means that we'll be in violation. And again, I'll go back to our NOV Exhibit 1, where we were in this exact situation and we were told that we needed to get ahead of it. And so I appeared before you today. So that's my answer to the first bullet.
Okay, so what you want to walk down A, B, C. Do you want to walk all the way down and kind of provide?
Chairman Ali, as to the good portion, the district may be able to assist for some efficiency
Not
with
a problem.
questioning. If
Not a
there's no
problem at
objection.
all.
No
Was
objection.
this a
objection.
question about a timeline?
Sure.
Okay. Mr. Munoz, I'm looking at your petition at question number 4. Is it accurate to say the equipment went offline in an emergency outage on August 28th?
It is.
I'm looking at the petition and it's filed by the clerk, stamped and dated September 6th. Is that consistent with your recollection that you filed the petition by September 6th?
Yes.
Are there currently any emissions coming from the unit?
No.
All right. The district posits that the petitioner acted with diligence. There's no currently emissions, so there's no harm to the environment. And I think a finding of good cause can be made.
All right. Any members of the hearing board like to, ma'am, go right ahead, Ms. Verdugo Prata.
We have in the state of California, many companies like the one that Mr. Munoz is the compliance officer for, and they are in a catch-22 situation. The fact that it is about timing and it's all about Cal ISO requesting when they're going to deploy and when they're going to ask that company to come online to be able to provide enough electricity throughout the state. And my concern is that what do companies like this do? I can find good cause, but my concern is if the district is against the regular part of this variance request, what do companies like this do? What's the answer? I don't think there is a real good answer for them, and they are going to be penalized because of that. And I think there needs to be some type of a development of a protocol that the district and these companies can come to, because he's not going to be the only one. And that is my concern. And when Cal ISO requests that they come online, it's instantaneous. You know, they need that power right now. They don't know yesterday that they may need it tomorrow because it's all about the demand. So how do you, there's no way, you know, you can look at the historical usage and the history of demand within the state, but that still doesn't mean that they are specifically going to ask this company. They may ask company A, company B, company C before they come to this company, or they could ask him to come online first. And that he has no control over that. That company has no control. It's all about what Cal ISO wants to do. So how do they stay in compliance with the AQMD and still be able to provide the demand that the Cal ISO is asking them for? So my concern is that this is not going to be the only one, and that we need to find an answer somewhere that they can still be in compliance. They can do what AQMD needs them to do, but obviously it is a timing situation that he has no control over. So I think that once we get past good cause, because I believe also that there is enough here to take me to that conclusion. But my concern is, what about the rest of it?
Thank you for your comments, Ms. Verduga Peralta. We'll address those on the merits by describing the many, many off-ramps the rules already provide for.
Okay, thank you.
Mr. Buttercup.
No, I think let's stick to the first phase, which is the good cause. And I do believe as in testimony provided and Ms. Menway questioning, we can find good cause to proceed to the merits of the interim variance. The petitioner is in violation because they were supposed to write it as at 18. The date is passed. They have not done it. The circumstance leading the violation could not have been avoided. There was some fault in the generator, the turbine that caused that.
I'm sorry, I actually I didn't hear clearly your first statement.
Oh, the first, which one? I said I can find good cause. I'm going through the 4 points that one day in violation because they have not done the radar test by September 18, according to Mr. Muni's testimony. That was due, the 6 months testing, radar was due.
The petition states that the RADA test is due on September 30th. They are not in violation, and they will not be in violation until they reassemble the engine, commission it, and operate for 14 days without scheduling the RADA.
You heard Mr. Muni's testimony, he says September 18, so.
He had a RADA test scheduled for September 18th and was unable to perform it because they disassembled the engine.
I stand corrected. So it is due on September 30th. So it's not in violation yet, but it's imminently could be in violation by September 30th if it doesn't form the radar test.
The engine is disassembled
I know
according to the
that, but
petition.
the-
So
yeah.
no, consistent with my opening statement, the testimony you'll hear from Mr. Maxwell, there's multiple off-ramps provided in the rule. He will not be in violation until he recommissions, starts operating, operates 14 days, and chooses not to do a RADA test.
Okay, Ms. Penrang, I'm going to go through the the findings here. So if you will not interrupt me, let me go through it. If I'm wrong, you can then provide, because I'm going through, and I stand corrected on the violation date. It's, as you said, in the petition is September 30th. That's when the radar test is supposed to be performed. That they cannot do because the turbine is not operating. Unavoidable circumstances led to it not in operation. So that's number 2. And then the third one is the diligence of filing, as you indicated. They were diligent in filing. August 28th is when it happened. And I think they filed it September 6th when they filed it with the district. So they were pretty diligent in filing, and the denial will result, I think, in unavoidable adverse impact of petitioner. So I do find the good cause findings for us to proceed to the next phase.
Are you inviting questioning or?
No, I'm saying for the record, that's all.
Okay, so
Yeah.
you're making your declarative statement,
Yeah,
and he finds good cause. Dr. Abraham, do you also find good cause as well, sir?
I do find good cause as well.
Okay, all right, so at this time, would you like to entertain a motion on?
yes.
Well, hold on, just to be very clear, did you have any closing statements?
I do not.
Okay, Ms. Manwaring, any closing statements?
Yes,
on the
just
good
very
cause?
briefly. The district's position is there is not currently a violation, and there is no risk of there being a violation on September 30th if the engine is not reassembled and commissioned by the 30th.
Now, okay,
Go right ahead,
in
sir.
same token, you said the district find good cause. To find good cause, you have to make the first finding, which they are in violation or will be in violation. But so you're talking on both sides now.
I am, and I am referencing a different good cause finding, and I will stand corrected if those are the findings to proceed to the merits.
Right.
I thought this was diligence in petitioning
Okay.
and harm to the environment for not finding good cause. If in fact those are the 4 findings required to proceed to the merits for an interim variance.
As per the health and safety code.
Okay.
So we need a motion.
Yeah, so
Yes.
go right ahead and proffer a motion, Mr. Belakapalani, if you're so
Well, I
inclined.
just want to make sure that Mrs. Manwaring agrees that,
It is the board's motion and the board's
yes,
vote. But the board, thank you for bringing that to my attention. If a finding of in or will be in violation is required for good cause to proceed to the merits, the district objects to a finding of good cause because the violation here is far too speculative.
Mr. Belakapalani.
All right,
the
so
floor is yours.
I will make a motion that in the matter of Henry Holdings LLC, case number 6088-2, I move that we find good cause to proceed to a hearing for an interim in absence of notice to the public based on a discussion ability to make the findings for good cause.
Friendly amendment, I think the case number is 6248-2.
Oh, I'm sorry, I was looking at the wrong one. Thank you.
And and you second his motion?
Yes, I do.
Okay, his motion second, just for the discussion, I want to clarify, I called you Energy Holdings and it's Enry. I want to apologize for that. Okay. All right, at this time, we'd call for the roll. Dr. Abraham on good cause.
Aye.
Ms. Verdugo Peralta,
Aye.
Mr. Belakapalani.
Aye.
Ali on good cause votes aye, and the matter is approved unanimously. We'll move into the second phase of the hearing, and we'll bring over all exhibits and testimony as provided in the first part. I'm going to open up the floor to you, sir, for your opening comments on this particular phase of the hearing.
And this particular phase of the hearings are A through F?
No, we've already established, yeah, we've already, right, we've already established good cause.
6 findings now.
Right.
The A to F, yes.
We've already made them, or
No, you have to make those
Okay.
6 findings.
Yeah, you have to make them, but we've already established good cause to proceed forward to this aspect of the hearing.
Thank you.
So if you reference, she said earlier, this is a bifurcated hearing. Had we not established good cause, then we would pretty much be on our way out of here.
Well, I'm glad that I didn't get the bum rush.
Right.
So for number A, we don't think that it's that outrageous of a speculation that we won't be able to comply with Rule 212 Attachment C, in that
Okay. Yeah, I'm sorry to interrupt. You keep repeating 212, it's 2012, right?
2012.
Okay, thank you.
Yes, thank you. It's happened in the past. We don't know when our commissioning date is. We have a hard stop on the 1st of March. There's only 6 vendors who can perform our tests. None of them can commit to a timeline. And so we will be in the unenviable position, as the board member pointed out, of getting an order from the CAISO and AQMD saying you've already started 14 times and your 15th is actually a violation that will go into an NOV, and we will be penalized as we were in 2019. So for A, I would say that we will be in violation. We can see a situation, and it's already happened in the past, where we will be in violation. I'll stop there and see if there's any questions on A. Or do I continue on all the way through?
Yeah, you continue on, my friend.
Okay, thank you. That the due conditions are beyond the reasonable control of the petitioner, requiring compliance would result in an arbitrary and unreasonable taking of property. We think that denying the petition is unreasonable in that there are no excess emissions and no hazard to the public that is going to occur. We continue to monitor our emissions, although the gas turbine is disassembled, so it couldn't generate anyway. But on the 15th run day, we would be in violation. And so if there's no damage to the public, that this is only a rule issue that we've already been penalized for once. And we don't want to get into that situation again. We learned from 2019, which is why I'm here. And I'm really surprised that AQMD is opposing this, council is opposing this, when this is the course of action they told us to file in 2019 and penalized us for not doing it. So I don't understand why they're opposing it, and I believe that it would be unreasonable. For C, that the closing and taking would be without corresponding benefit in reducing air contaminations. There will be no excess emissions. So we don't think that that's an issue. D, that the applicant for variance has given consideration to curtailing operations of the source in lieu of obtaining a variance. This, as the board member correctly pointed out, is beyond our control. We are on the FERC list of generators. We're subject to the tariff. When CAISO tells us to run, it's not an option, it's an order, and we're subject to criminal penalties if we don't. That the application for variance has given consideration, oh, we did curtailing. So during the period of variance, the applicant will reduce excess emissions. There will be no emissions during the variance that are not accounted for in our permit. F is during the period the variance is in effect that the applicant will monitor or otherwise quantify emission levels, et cetera. We continue to have a AQMD approved continuous emission monitoring system monitoring our stack 24/7, 365. Those findings are uploaded into the AQMD RTU database daily, so there's no violation there. Those are my statements.
All right, Ms. Manwaring?
Good morning, Ms. Conacher-Macklin.
Good morning. I apologize.
Okay. Mr. Munoz, I'd like to draw your attention to what you've introduced as Exhibit 2, which is the Notice of Violation P66066. Has the board been provided copies with the document? Okay. Mr.
Yes,
Is the NOV marked as Exhibit 1?
yes, the NOV
Thank you for the
is
correction.
marked as Exhibit 1.
Exhibit 1. Mr. Munoz, is Exhibit 1 a true and correct copy of the NOV you received from the district?
It is.
All right, I'd like to move that into evidence.
Yes, indeed.
Focusing on the fifth citation, which is relevant to why we're here today, could you tell us, to the best of your recollection, what was the conversation you had with the inspector about seeking a variance at that time?
I don't believe I had any conversation with the inspector about seeking a variance for number 5.
All right. Would you clarify your testimony in your opening statement when you spoke as to someone advising to get you a variance to avoid this and getting ahead of it?
Yes, I believe it was Miss Sherry. I can't pronounce her.
Is she in the legal counsel?
She is in legal counsel. Yes.
That's my colleague, Hanajad. Sherry,
Okay.
yes, thank you.
So Ms. Sherry indicated that we should have been proactive in seeking a variance for this situation.
All right. And was her advice seeking a variance prior to the date the test was due, or was her advice to seek a variance prior to the 14th run day?
That's a nuance that I probably didn't understand then, and so I can't answer that.
Okay. Do you understand the significance of my question as we sit here now?
I'm very simple, so if you'll explain it to me, I would appreciate it.
Oh, Mr. Munoz, you're far too self-deprecating. Let me ask it this way. Are you currently in violation?
We are not.
Will you be in violation of your obligation to perform a RADA on D19 if it's not performed by September 30th?
No.
Right. What is your understanding of when a violation will arise?
It will arise on the 15th day that emissions have exited our stack.
Historically, have you been called up 15 consecutive days?
Yes, we run consecutive from July through September 30th. almost consistently over the last 20 years.
Right.
And the other days, for the other days of the year, we, as board member indicated, we don't ever know. And there's been a shift in patterns now, in that it used to be that California had a peak summer season, but now there's also a peak winter season. And the load has changed so that they call it, instead of the duck curve, the canyon curve, in that load is high, not only as you would expect from 1800 to 2200 when people come home and turn on their AC, but also now from 06 to 08.
All right, returning again to the fifth citation on Exhibit 1. Do you recall the period of time over which the 14 operating days occurred?
I believe the 15th operating day occurred somewhere the first week of March or the first week of April, the end of March is my recollection, but I'm not sure about that.
Okay. If I told you the inspector would testify that the first run day was in February, would that sound consistent with your recollection?
The first run day is accurate in February. I believe it was February 2nd.
And your recollection is that by mid-April, you would hit the 15th run day?
I want to say the first week of April, we had hit the 15th run day. But again, I know that I submitted a report to AQMD indicating the exact dates, so I think I would defer to that.
All right, we appreciate that, and I don't expect anyone's memory to be that precise. You testified in your opening statement that it takes about 2 months to schedule a RADA.
Historically, we schedule 2 months in advance because we can't go shorter and be assured that we're going to get our tester on site.
Okay. And if you were running in February and March of 2019 and to the best of your recollection, hit your 15th run day in April, didn't that provide enough time? Didn't that provide more than 2 months to schedule a RADA?
So as the board member indicated, we don't know when we're going to run. And historically, we don't run January and February and early March. Maybe we will run one day. So it was, and I think we only ran February 2nd and March, the second week of March in 2019. And so then we did schedule a RADA, and the soonest we could schedule it was after the 15 days. So we were surprised, I guess is my answer.
How many days if you recall, how many days had the engine run by the time you decided to try to schedule the RADA?
3, I think.
Okay. And at any point, did you consider filing a variance when you scheduled the RADA and it would take 2 full months?
Mea culpa, I was ignorant of that, of this board's presence and the ability to do that.
All right. And I believe that is why my colleague, Ms. Henner-Azad, probably advised you that this is an option. But what I'm getting at is those circumstances are different than as we sit here today because your testing deadline has not yet passed. So can you tell this board on what day will you be in violation of your permit condition requiring you to run the RADA?
On the 15th day of run.
All right. And what month will that occur in?
We don't know, which is why I'm sitting in front of the board right now, because I can anticipate it happening in January or February or in April, May, and June.
You testified in your opening that you had a RADA scheduled to comply with a permit condition on September 18th. Is that accurate?
Yes, that is accurate.
What company was that scheduled with?
Montrose.
Montrose. And when did you reach out to Montrose to schedule that test?
In May, I think we issued the purchase order.
And did you issue the purchase order in May and the earliest possible date they could test was September 18th? Or did you schedule for September 18th in order to comply with your deadline?
Typically, they're the limiting factor. And so we have some limitations in that we don't want to test on during So CAISO issues certain days that they think are going to be particularly problematic, a heat wave. And so we have to try to figure out when those days are with our NOAA information, National Oceanic and Atmospheric Agency, to determine when we can schedule a RADA and when Montrose is available. So it's an amalgamation of both their schedule and what CAISO will allow and our schedule.
All right, so in May, you were able to secure a September date.
Yes.
Just to clarify, it is not your testimony that September 18th was the very first date that they were willing to offer you, is it?
No.
Scheduled it to comply with the deadline.
To comply with the deadline and to not be in violation of the CAISO's limitations on operations during heat domes and heat-related activities.
Are you able to run a RADA on a day CalISO calls you up?
Yes,
Is it your preference to run the RADA on the day CalISO calls you up?
absolutely.
Could you tell this board why you prefer to wait until CalISO calls you up before scheduling a RADA?
Because then we don't have to incur the $40,000 run cost. So natural gas is one cost. Let's say it's, $4. Then we buy that at the Henry Hub in Louisiana. We have to ship it to Needles. That's called a basis number. That's about $2.40. And then we have to ship it with SoCal Gas and pay the Cal Egert payment, which is about $2.40 again. And so at the end of the day, when we run a 12-hour RADA, it costs us not only the $20,000 for the vendor, but also $40,000 in fuel costs and operating costs for the gas. So we're a commercial business. We try to make money. And so we would prefer to run our RADAs during an operations day, but that almost never happens in the first RADA that we conduct in any calendar year, because it's usually in March that we do it, and we are almost never dispatched in March.
I'm going to turn my attention to the status of D19, please. What is the current status of D19? Is it disassembled, or is it more precise to say components are disassembled?
D19 is not disassembled. It's fully assembled. It has a shaft that comes out of the gas turbine. D19 is our gas turbine, and it has a shaft that comes out of the gas turbine into the gas turbine generator, and the generator is what is disassembled right now. So you can't spin the gas turbine because the gas turbine generator to which the gas turbine is connected is disassembled.
All right, so there's no possibility that the engine can run.
No.
Okay. And in your opening, you discussed how parts were sent to Florida for repair.
To the electric machinery depot in Pensacola, Florida.
And you anticipate 2 to 4 months before those that equipment is returned and can be reinstalled?
We don't know. They arrived today, Wednesday.
Arrived where? In Florida?
In Florida.
Okay.
And so once we get an assessment, then we'll know, we hope to know a timeline. And timelines for us in our business have been extraordinarily long after the pandemic. We will wait 52 weeks, 56 weeks for components, and we don't know what components we're going to need now. So when we talk to EMWEG, they tell us 2 to 4 months.
Given that the parts are in Florida, it's premature to have an estimated timeline. Can you testify with certainty today that you will not be operating the turbine on September 30th?
I can confirm that.
Okay. What is the status of the fuel lines?
The fuel lines
Is a
are
fuel line
connected.
connected to D19?
They are.
All right. Why is a fuel line connected to D19 if it's not operational?
Because our fuel lines are calibrated instruments, and we continue to provide data as required by our permit through our continuous emission monitoring system to the AQMD RTU database.
If you were to disconnect the fuel line to D19, would that impact any other operations?
Yes.
Could you tell us how that would
Sure.
impact?
So at that point, we won't have any gas and we run 4 fuel gas compressors that compress the gas before it goes into the gas turbine. Those operations and preventive maintenance checks and services will have to come offline. I believe we have our gas lines calibrated by Dick Munn's company every year, and those will have to be redone because once you separate the gas line, I think there's something that we won't be able to do with it. I'm sure there's other things I'm not knowledgeable enough to indicate it, but I know that we don't want to do it.
All right. Tell me why you don't want to do it.
I just said because we won't be able to complete any preventive maintenance checks and services downstream from those gas flanges.
Okay. And is there anything downstream of those gas flanges other than D19?
Yes, there are the fuel gas compressors, there's the silica components, there's a number of components, compressor components that are separated or are downstream from those valves.
Do you know either in terms of timing or costs, what it might cost Energy to disconnect fuel lines?
Timing, it's a very short period of work. 2 people, 2 hours to disconnect them. Connecting them is a different issue. They are obviously the methane is a fairly large molecule, but you still have to ensure that all your piping's correct. You have to be recalibrated again. You have to run tests. You have to compress out fuel up the line system. So a significant body of work, which we would prefer not to do.
Okay. Let's talk about the SEMS. Is your SEMS currently operating?
It is.
It is. And is there any fuel flowing into the turbine that would be reported on the SEMS?
No.
No. So your SEMS is reporting valid 0 data points?
Yes,
And you continue to report that?
we do.
All right. Are you familiar with the provision in Rule 2012, about not being required to operate SEMS if the underlying equipment is not operational?
I do remember that.
Okay. Just want to apologize for being a little repetitive. I want to walk through the timeline. Around August 28th, you knew there was an issue. You took the turbine offline. You filed this petition by September 6th. You had a RADA test scheduled that is obviously beyond your reasonable control to perform that scheduled RADA. It has been your testimony today that you could schedule a RADA in about 2 months and that you have been able to schedule a RADA 4 months in advance.
That particular
Why
RADA.
do you believe that you will? Why are you certain you'll be in violation at some point?
I'm not certain. I think there's a high likelihood that we will be because it's happened before.
Okay,
Again, I'll go back to the board members' comment that we don't know what the schedule is going to be, but when the Cal ISO calls us, there's no, it's an order, it's not a request. And that can happen because of the changes in the peak loads in California. We think it's very likely to happen. And so again, we don't understand why council is against our petition, given that we're here because of an education that your colleague Sherry gave me in 2019. That's my answer.
in the NOV that you received for the late run RADA in 2019, is it because you missed the deadline or because you operated for 15 days without performing the RADA?
Both. We had not completed a RADA within 6 months, and we were due a RADA, and then we one of your off ramps was, well, you can operate for 14 days, and we did, and CAISO ordered us to operate on the 15th day, and we were in violation of our permit.
And what's the period of time that elapsed? We already had this testimony, but I
On the
would like you
1st
to
of
tell this
January.
board how many months passed between the first run time and the 15th run time.
From the 1st of January, or the first run was to February, I believe, in 2019. And I think we violated our permit in April. And I know that you're I'll try to get ahead of your questions here. I know that you're saying that the situation in 2019 isn't the same as the situation is here, and we would agree. We would say that the likelihood of violating our permit is greater here. And the reason is because the timeline of when we could reassemble our gas turbine generator. Let's assume that the best case scenario, we're ready to run on the 1st of January. We run, and now we're outside of our 6 months window, so we've got 14 starts. We're going to consume 2 of those in commissioning starts. And then from the first week of January through the 28th of February, we'll try to schedule a RADA. There's no option for us. We will schedule it if we can get it. But let's just assume we can't. If we can't get that RADA, we could very easily be called to generate January and February of 2025 or 12 or more days. So we think it's a high likelihood.
And if that occurs as you approach the 10th, 11th, 12th day, are you aware that a variance could be requested at that time and the violation would have much more certainty? That is the advice that the legal counsel had offered you.
No, it's not. It's get ahead of it. And we know that we can use our historical knowledge to say what the situation is now, what the likelihood is. I don't understand what the difference would be other than your perception of certainty of having to do an emergency variance. I think that's what it's called, which is what we're doing right now because we don't have the time to do a 45-day regular variance. We do we do an emergency variance. And I don't understand why council would prefer us to be in a situation where we're doing an emergency variance versus an interim variance to get to a regular variance. So I understand what you're saying. I don't agree with it at all. Why do I want to wait?
What you're asking me is a legal question, and that is because the first finding that you need to make is or will be in violation. And your testimony is you will be in violation the 15th day if you don't schedule a RADA, but you've also testified you could schedule a RADA in 2 months and you will schedule a RADA.
I think that the way that it's worded is it likely? And we think that it's very likely that we're going to be in violation, which is why we sit in front of you today.
Chair Ali, you had requested some emails be provided. We have those available to distribute at this
Thank you.
time.
Thank you very kindly. And we'll mark those as Exhibit A. Madam Clerk, is that accurate, Exhibit A? Okay, very well. Thank you.
Thank you.
Ms. McWilliams, can we get an email copy sent to the clerk's office so we can get it to Dr. Abraham?
Absolutely. Apologies, I didn't.
No, not a problem. And so, Dr. Abraham, what we have before us, as well as general public, we have an exhibit marked A. This is what I requested earlier was simply the email traffic between the attorneys for the district as well as Mr. Munoz, just to be able to provide a little bit more clarity and context as far as the discussion is concerned. Okay, Ms. Manwaring, the floor is yours.
Right. Charlie, I just forwarded an email with the exhibit embedded to the clerk, and I'm requesting that Madam Clerk forward it to Dr. Abrams.
Thank you, thank you.
Thank you.
All right, Ms. Manwaring, will you?
Yes.
still
I'd like
question?
to return to where we were discussing. Mr. Munoz, I want you to know that it is not my perception of certainty or my desire to make this a difficult process for you, but rather a requirement of law. The facility is or will be in violation is the very first finding. And what I've heard you testify is that you can schedule a test in 2 months. You will schedule the test in 2 months. When you had the violation previously, it's because you didn't schedule until you got to the run day.
I'd like to correct
And-
that. I don't think that's what you just said is true. I said we
All
will
right, I defer,
try.
please.
We will try to schedule it as soon as we go online. We don't have a certainty that we will, and there's a high likelihood that we could fire 12 or more days in January and February 2025. So we will try to schedule it, but there's no certainty, as I've demonstrated or as I've testified previously, that we'll be able to comply with that.
But you would have to choose not to run the RADA test on 14 different occasions, or 12 if we don't count the 2 for commissioning. Every time, that's your choice.
No, it's not. It's a scheduling choice. We don't know when we're going to run.
Right, but that's your preference. It's not beyond your reasonable control to wait until CalISO calls you up in order to run.
Yeah, I agree with that. And what I said was, if we commissioned on the 1st of January, ran twice to commission, now we have 12 run days, we would immediately try to schedule a RADA. We would, as we have done every year since 2013.
What's-
But we don't know for sure that we will be able to do it. Historically, we have not been able to schedule a RADA on a short notice. And as I said, it's usually 2 months before we can schedule it. That would take us into March and into our second outage.
When you say historically you've not been able to schedule a RADA on short notice, do you mean you have not been able to schedule it on the day that CalISO calls you up?
No,
What do you mean then?
I mean that we know that we have to schedule a day, let's say it's the second RADA of the year. We know that we have limitations on weather and the CAISO telling us when we're not going to be able to modify any of our settings. And then we say, and when is, in this case, Montrose, we've used other vendors, able to schedule. That's the second, usually the second RADA, and they're very, very busy in the summer. So we have to schedule, as I said, this time I think we issued the PO very early in the year to do it. On our first RADA of the year, typically we do it in February or March. And again, we have to schedule those far in advance. So I think it's 2 different scenarios, and it's always a long time.
Is there anything preventing you from reaching out to a testing company and issuing a purchase order to run a RADA in January?
There's nothing preventing me other than good business sense.
Why would it not be good business sense to get ahead and get it scheduled, just like you did in May of this year?
Because I don't know when the gas turbine's going to come online, and a purchase order is covered by the Uniform Commercial Code. And as soon as I issue it, I'm issuing a check for $20,000.
So did you pay a testing company $20,000 in May of this year to reserve the September 18th testing date?
Yes, I wrote a purchase order, and that is a claim for payment on the part of Montrose.
Okay, and is there any policy or business reason why you couldn't simply take that money already paid and test already scheduled and push it out?
Because I set them for a date, they're going to charge me for that date. I reserved their men and materials. I don't think I'm getting a refund for it.
Is it your testimony that the $40,000 or $20,000 that you have to pay to a testing company is a sunk cost and a lost cost if you have to cancel the testing date?
It has historically been, yes.
It's interesting. Okay. I'd like to turn your attention to what's been marked as Exhibit A, the email exchanges between you and I. I'm going to give you a moment to look at it, and I'm going to ask you if you agree this is a true and correct copy of emails between you and
I
I.
read it and I agree.
Okay.
Yeah, you know what, Ms. Minowing, if you will indulge the body, can we take about 5 minutes to go off the record, just so members of the board can just review Exhibit A?
Absolutely. He just testified it's a true and correct copy. I'd like it moved into evidence.
Okay, it's in evidence. It will be received as well as marked as Exhibit A, as previously stated. We'll take about 10 minutes. We'll come back at 10:47. We'll allow the board members to review the documents. We're off the record, Mr. Day.
I'm sorry, Chair, how long did you say?
10 minutes, because it gives us a chance to run to the little fella's room.
Let's look at the rotation.
Oh, okay, because my son, yeah, he's in LA now. So he was doing DUIs. Oh, wouldn't that be interesting? Yeah. I'm just gonna get coffee, I'll be right back. That's insane. Discussion.
Can you hear us now?
Yep, I can hear you loud and clear.
Okay, we're going to go back on the record. Okay, so a new exhibit, we're back on the record at 10:49 a.m. A new exhibit was entered into the record. Are there any objections from the petitioner? Mr. Munoz, you object to?
Yes, Mr. Chairman, I object to Rule 212.
No. Do you object to this exhibit being entered into the record? Just wanted to make sure are you comfortable?
Is it 212?
Yes.
I object.
What is the basis of your objection, sir?
In preparation for this hearing, I went to the AQMD website to download Rule 212, and I downloaded what was the official copy of Rule 212, and that download doesn't include Attachment C. I was concerned with that. I sent that document to Mr. Lee there and told him that I didn't think that Rule C was part of the official record. And so he said I needed to address it with somebody else. But so I have not had confirmation or a copy other than today that Rule C exists. Council has showed me on her laptop that Rule C does exist on the AQMD website. I'm testifying right now that I did that. I downloaded the original copy and it does not contain Attachment C.
Okay, Mr. Munoz, I do respect your objection. We're gonna overrule it. I'm gonna allow it. And so we're gonna take another 5 minutes. Mr. Day will come back at 10:55 a.m., 10:55 a.m. We're gonna allow members of the hearing board to review Exhibit B, which is Rule 212 Protocol Attachment C. Rule 212 Protocol Attachment C.
Chair Ali,
Yes.
it may be efficient and useful if I just briefly introduce because it is not a complete copy of the entire protocol.
Okay,
So I'd like to connect.
not a problem. Go right
Thank you.
ahead.
I'd like to connect Exhibit A and Exhibit B.
Okay, fair enough.
Exhibit A are the emails that you requested in which I directed Mr. Munoz's attention to Rule 2012 Attachment C, B to C. So that's the portion that you have here. This is the one of the off ramps I referred to. It is the off ramp referred to in the emails in Exhibit A.
Okay, Ms.
Mr. Chair?
Rodriguez-Peralta, yes, ma'am.
Yeah. Maybe it might be better, Ms. Manwaring, if you explain it, because a lot of this verbiage is not
Yeah, let me
something
take
that.
a few moments.
Yeah.
I'll explain it because I've not taken the oath. My statements are not testimony, but this is exactly the nature of the testimony. We're going to be bringing Mr. Maxwell to explain all the different off ramps, including this one, which is available to Mr. Munoz and which in the district's position makes the violation far too speculative. So you've heard lots of testimony about performing a RADA before the 14th operating day. The district rule writers have worked very hard over the years to create off ramps. Provision B, which is not before you, says if a unit's not operating for 2 quarters, you can avail yourself of an automatic 14 operating day delay. C says if the unit's not operational during the time the ROD is due, you can automatically avail yourself of a 14 operating day extension. That's what this says. Says, show us the fuel lines are disconnected and you don't have to do your RADA until your 14th operating day. Now, there are turbines that never reach 14 operating days in a season. And sometimes 14 operating days take 6 months to happen. So that is the purpose of this rule, to provide the guidelines for how to implement the automatic delay you're entitled to when certain circumstances are met. And to tie it back to earlier testimony, the NOV at issue citation 5 was because he was not operating for 2 quarters, and provision B, which is not before you because it didn't want to overwhelm you with too much, but provision B says because you weren't operating for the prior 2 quarters, you automatically had the 14 operating day extension. The testimony earlier was that the operating days occurred before a RADA was tested. And we're going to present a witness that's going to dispute, admittedly, not a precise recollection, but our witness will testify that those operating days took place between February and July. The district's position is there's plenty of time to schedule a RADA between now and the potential 14th day that this rule provides for.
Can we start asking questions of,
Well,
I think
so,
we're gonna take a
what,
break.
well, no, she still had the floor. Were you still questioning the gentleman?
I believe you had requested a short recess to
Yes.
look at this, and I was explaining how A and B are connected.
Well, do we still need the recess? Okay, all right, fair enough. So we don't need the recess, but you did have the floor and you were questioning Mr. Munoz. So did you want to resume
Yes,
that?
thank
Okay,
you.
very well. Then we'll
All right,
come back
thank
and we'll take members' questions.
All right, Mr. Mooney, directing your attention to Exhibit A, which is the email exchange. I'd like to draw your attention to your response on September 13th, which admittedly was directed to me, but Mr. Choi is the secretary that I work with. That email was to me. I'm going to read the short email and then just ask you to explain to the board what your understanding intention was here. Thank you for the email. Unfortunately, we cannot use Rule 212, Attachment C, subparagraph B to C. The CAISO retains the right to order iGen to fire. Therefore, we cannot disconnect our fuel source. There are few AQMD approved vendors who can execute a RADA and none on short notice. We would not be able to comply with our obligations if we use this rule. Okay. Recognizing that it will be a little bit redundant from our earlier testimony, could you please explain to the board why you don't think B2C is available to you?
Well, on September 13th, I didn't think that it was available to us because we didn't know the extent of the damage. We were all hoping that we'd be able to come up and provide energy as ordered in September. And so to disconnect our fuel line didn't give us any benefit. We weren't going to be out of compliance until the 1st of October. And then if we would have disconnected our fuel lines, there would be no benefit. We already had the same rights for 14 firing days under the being delayed on our RADA as we would if we disconnected our fuel line. So there would be no benefit. The disadvantage is that we would introduce a situation where we're disassembling and going out of compliance with our other equipment, so that if it had been a short outage and we had disconnected our fuel lines, we would then have to purge, recertify, catch up on all of the PMs that weren't done on a pressure vessel, and that could take a significant amount of time.
Hours, days, weeks, months, when you say significant?
Well, it wouldn't be our time. It would be our vendor time. And as I testified, lead times are very, very long now after the pandemic. So I can't tell you, but I know that it wouldn't be in September.
All right, so 2 hours, 2 people to disconnect the fuel line, but an uncertain amount of time and vendors to reconnect, calibrate, purge, and the other steps you just.
And I don't think that we're allowed. I've got to check our tariff rules. I don't think we're allowed during our peak season to disassemble any component of the plant.
Could you define peak season?
It usually is the 1st of July through the 30th of September. And now it encompasses components of December, January, and February.
So peak season is not consecutive or 2 independently identified peak seasons?
2 independently identified peak seasons.
In your answer to my question just there, you said we were already entitled to the 14 days. Could you help me understand what entitled you to the 14 days to extend the RADA?
Rule 212 Protocol Attachment C, I believe, indicates that after we're out of compliance with our RADA, we can fire 14 days before we're in violation of our permit.
So it's your understanding if you miss a testing deadline, September 30th, you can fire for 14 days?
Before we have to complete a RADA. That's my understanding.
Under what circumstances would a violation have arisen on September 30th.
No situation.
So September 30th is not and was not a testing deadline because your understanding is that even when you miss a RADA deadline for a functioning turbine.
I believe that's what you said in one of these emails to me, was that we had, and that's what we were speaking about earlier this morning, was that you testified to the board that there wouldn't be a violation because we have a grace period of 14 firing days.
Okay, thank you very much for sharing with your understanding, but I referred to a rule-based delay on the RADA testing. I did not use the term grace period. And in fact, our line of questioning earlier, I was trying to differentiate a violation for missing a deadline versus a violation that you received in Exhibit 1 for not scheduling the RADA during the 14 days. Am I explaining two different potential violations clearly?
I don't know.
Okay.
If my understanding is incorrect, please correct me. My understanding from your earlier testimony this morning and from this email chain is that we would not be in violation of our RADA testing obligation on the 1st of October because we had an off-ramp of 14 firing days to complete a RADA before we would actually be in violation. Is that correct or not correct understanding?
That does not include all the subcomponents of B2B, but that is essentially consistent. The remaining subcomponents would be blind flanging the fuel line and then before starting up, doing a cylinder gas.
Okay, then I think you're having me chase my tail. So the answer to your question is on the 1st of October, we would not be in violation of our RADA test obligation because we have 14 firing days to comply, which is what I understood. And the reason I'm in front of the board is because I can foresee a situation where we will fire for 14 days before after we commission from our repairs, before we will be able to complete a RADA. And that's why I'm here to get in front of this.
Let's go back to the timeline for completing your repairs. With the understanding that there is a lack of certainty, what do you anticipate the timeline being moving forward? And what are the unknowns?
I've already testified to that, so I'll repeat it here. We don't know how long it will take for our exciter rotor to be returned to us. We generally know from the vendor, EMWEG, that it is a 2 to 4 month lead time. Our assembly arrives today, and we will know something more after they evaluate it. I'm assuming sometime this week. Best case scenario, we would like to come up sometime the first week of January. We will fire 2 times to commission the repaired item, and then we will immediately try to schedule a RADA before we go into outage on the 1st of March. I don't have any certainty, and I think it's unlikely that we will be able to do that, to be able to schedule a RADA after we come up from, let's say, the middle of January through the end of February, but we're going to try if that's the scenario. I think that it's likely that at that point we will fire for 14 days due to a CAISO order, not because we want to, and we'll be forced to comply and we'll be out of our permit. And so what is vexing me is that it seems that you are advocating that we wait for an emergency to do this hearing as opposed to something that the rules allow, which is an interim and then a regular variance, because there's no detriment to the population. We're not creating excess emissions. So that's the way I see it.
And I appreciate that, and I understand your frustration, but it is not me, it is the law, whether regular or interim, that all 6 findings independently be made. And I'm having trouble identifying is or will be in violation because we have no idea if you will be called up 15 days before you go out again in March. Let me ask a series of questions. You've previously testified that it historically takes about 2 months lead time to schedule a test, correct?
Correct.
You previously testified that you can schedule a test 4 months out, correct?
We can schedule it longer if we have the need, or if it's like a summer where we can look at the NOAA data and give an accurate prediction. But it's minimum 2 months. It can be longer than 4 months.
But you can schedule more than 4 months in advance, right?
I can.
Right, okay. Is there anything stopping you, what is stopping you from reaching out to a testing company and scheduling the test for, after you've commissioned for 2 days?
Because I don't know when commissioning is going to be. If, so I'm scheduling, schedule implies that you know a particular date and time. If I don't know when I'm going to commission, then I don't know when I'm capable of running the plant for errata. Does that answer your question? You're looking at me like I don't know.
No, that was very responsive.
Okay, thank
I don't always have the best poker face. Sometimes it's a thinking face.
So now that my mind's going around with that, you can't schedule for a date that you don't know. And that's why I'm here, because I don't know if I'm going to be forced to run, but I don't want to be in an emergency situation where I'm calling you guys at Christmas and I'm saying, I've got to have an emergency. I don't know why AQMD would force me into an emergency situation when we're sitting right here and the rules allow an interim and a regular. And I think that you haven't corrected me on my belief that it's not whether I will be in violation, it's whether I'm likely to be, or there's a possibility that I'm in violation. And I think that's high.
Okay. You've testified that you have a scheduled outage in March of 2025?
Correct.
March 1st or?
It'll start at midnight on the 28th of February, and it's supposed to end tentatively on the 31st of March at 0000, but our last outage extended for, I think, an additional month because of the delays with our supply chain.
Okay. So as we sit here today, you are not in violation. And as you've testified, you will not be in violation until the 15th run day, minus errata. We don't have any information about when the turbine will be recommissioned. You do have a scheduled outage in March. So is it fair to say that you're asking this board for a variance in the event that you're called up for 15 days prior to March, the March outage, after you commission? Is that essentially the period that you're looking for between recommissioning and going out in March?
No,
Okay, please
it's
help me
that
understand.
period, which we don't even know whether we'll have our parts back yet. So if we do have it back and we do commission in January, then that's a risk period. But there's also a risk period after we come out of our outage. Let's say it ends up being like last outage and it's 2 months. So we're out for March and April. And then now we're into a heavy run season. And the 6 vendors who test at 100.1, I know that I'm not going to get them out in 2 weeks. It's going to be months in advance that I'm able to schedule a run after I commission. And so now I'm looking at, if we come back online on the 30th of April, I'm looking at May and June for me to get errata in, and I'm going to do it as quickly as I possibly can. But that's another risk period where I could easily exceed 14 run days.
Okay, but historically, you've been able to schedule a test within 2 months, which is the timeline you just described.
Yes.
All right.
About 2 months.
Yeah. I'm going to reserve the opportunity to redirect after the district calls a witness, but I have no further questions for Mr. Munoz right now.
Okay, members of the board. Verdugo Peralta.
Thank you, Mr. Chair. Mr. Munoz, I'm trying to see the forest for the tree. I think there's so much that my fellow board members may not be aware of that goes on with a company like yours, that it really is a public need. Would you agree with that?
I would agree with that, and that's why we're federally regulated by the Federal Energy Regulatory Commission under a tariff.
Correct.
We have no options.
I also read in your petition that you have a cogen situation going on, the utilization of a waste heat to generate additional electricity.
Good catch, ma'am. Unfortunately, that situation no longer exists since 2013. The solar market has caused energy in California to be zero or negative. So our former customer, Mountain Water Power and Ice, or Mountain Water and Ice.
I know which one you're talking about.
Yeah, they have discontinued our contract for our waste heat. So now CAISO has directed us to generate at full capability using that steam.
Okay, and that is for additional electricity.
Yes, ma'am.
I also read in there that are you still producing hydrogen?
We are not producing hydrogen yet. Our pyrolysis project is scheduled to go online in 2025.
Okay, are you aware of the state's the state has received $2 billion to have hydrogen projects. Anything that's going to produce hydrogen is going to be a focus for the future, obviously, and the utilization. So that makes your company, I think, even more focused and more necessary for the future because of the fact that the state is going to now have, like they did before, a hydrogen focus. Would you agree with that?
I would agree with that. And, you point out a dilemma for us. So our plant is the first plant that is contracted with General Electric to modify our gas turbine to be able to consume both hydrogen and methane. So something that's very valuable for California. And in our load pocket, which is the Western Los Angeles Basin, there's a deficit of power. We import from Arizona, Utah, the hydro places up north, Washington, Oregon, about 20% of our power in our load pocket. And so to be able to burn hydrogen with reduced emissions is super important. The converse side of that is AQMD doesn't have any rules for converting our generator to hydrogen, even though it's what the governor has said and what the legislature has said. So we very much agree with your statement.
Okay. In reference to the fact you're a privately owned company, correct?
Yes, ma'am.
Okay, so it's not unreasonable that there's a fiscal responsibility to, as you said earlier, to utilize good business sense. And the fact of trying to avoid a large sum of money like $20,000 or $40,000 that you could possibly be forced to do. And in my opinion, the way that things have been asked and answered, that to me, that I don't think that you need to be forced into that situation. That concerns me. I don't think we're trying to harm businesses, and we're not trying to put them out of business. We're trying to encourage businesses. And at one time, there was a department here that they would go out to companies and together with the utilities to make sure that companies were able to grow. And I think that's you're in you're in that category. It's not really being done, but I think there's a need there and there's a void that's no longer. There is a small business assistance, but I don't know that you qualify for that small business assistance program, although I think that they still have the ability, and correct me if I'm wrong, Ms. Manwaring, to contact that part of the AQMD and ask questions so that they can understand the variance process or if they have other concerns or situations. That's still going on.
If a regulated facility has questions about the variance process, their best source is your clerk.
Yes,
The small business group is
we have a
available.
remarkable,
Yeah. Ms. Verdugo Peralta, these comments are very appropriate for deliberation, but we're still in questioning. Is there a
yes,
question
and I'm
for
trying
Mr.
to
Moon?
understand if, so I'm not so sure that he understands that. And it was my experience as a consultant to businesses and trying to navigate the variance process with the AQMD. So many businesses don't understand that process. It is onerous, and they have to jump through a lot of hoops that they don't understand. And that concerns me also, especially when I'm listening to the questions he's asking as well as answering for you, that it's going like this. You know, I'm not so sure that he understands exactly. For instance, if he didn't have that one part of the rule, and even if in reading the rule, it's not that easy to understand it, and that's why I asked you to explain it to the rest of us. But Mr. Munoz, did you have difficulty in when you were first trying to, because I remember when it was the situation before that there were so many questions that you had that
Excuse me,
wait.
objection. You're
I do have
referring
a
to a
question.
prior conversation that I'm not familiar with.
well, it's when I was chair, there was a situation that,
So I want to sustain that objection. Ask you to kind of rephrase, Ms. Verdugo Peralta.
yeah. This was before, I don't know, it wasn't before us, and the clerk brought it to my attention earlier that I don't know whether it was an emergency variance that we had at that time, and there was a lot of back and forth on that. Right, but there was, I have knowledge of it before. So-
Is your question to Mr. Munoz whether or not he understands the
Yes,
regulatory scheme?
Yes, because my understanding of this is that he didn't understand it in the beginning. And
Could you ask him that question?
yes, well, I kind of did earlier, but Mr. Munoz, did you have difficulty understanding the process when you were first, not only with the notice of violation, but with the whole process?
Yes, ma'am.
And it sounds like that. Do you have the ability to schedule the RADA at any time? I think that was discussed earlier, especially with this part of the Rule C in regards to the 14-day. Is it possible for you to choose a date?
We can not petition, we can schedule with the ISO the ability to fire on a particular day for the RADA tests, and we do that typically every year in March. The problem with this situation is we don't know when we will come online and when we will be able to schedule a RADA test.
Okay. So did you understand that you could utilize C of the rule to be able to do that?
Yes, ma'am.
Okay. Let's see. I had another question. I'm going to go ahead and let my other colleagues ask questions, and I may come back to other
Okay, so
questions.
just so I want to clarify the ground rules. Let us allow all discussion to go through the chair. I've kind of sort of sat back and watched. The hearing has taken on multiple lives of its own. So let us work through the chair so I don't have to necessarily be as vociferous or aggressive, as it were. But let's just comport ourselves, Miss. I believe you have the floor, Ms. Conaghan-Mackellar.
Yes. Okay, I've heard a lot of testimony concerning the scheduling. And my essential questions are this: is the scheduling up to you to determine the date? Or is there some factor that is beyond your control? And this is essential to the first issue that we must resolve in order to even grant a variance. So I need to have an answer to that question if I could.
It is not in my entire control.
Okay, entire control. What is out of your control?
The availability of the 6 vendors who can test under AQMD testing method 100.1.
Okay, but once you've made the determination that those 6 vendors are available, then and only then can you have a testing date, correct?
Yes, ma'am.
Okay. Has there been any effort to find out when these vendors will be available?
Yes, ma'am. I've called all 6 vendors and they need to know a particular date. Council asked me, why can't I schedule? A schedule implies a date and time. Right now, I don't know when the gas turbine will come back online and the plant will be permitted to run. We're waiting on the repairs and then the commissioning, and then I can schedule, but I can't schedule now.
Okay, do you have an estimate of when the repairs will be completed?
No, ma'am. As I said, the parts are arriving at the depot today. We will probably have some indication at the end of the week. Historically, this kind of an issue has taken 2 to 4 months, and that's the only information we have now.
All right, great. Thank you so much.
All right, Mr. Velakapalan.
Yes, thank you, Chair. Mr. Munoz, you had scheduled the tests originally for September 18th to meet the deadline of September 30th.
Yes, sir.
And if there was no failure of the turbine, you would have run the rider test.
Yes, sir.
And how many operating days would that have been?
84 or something like that. We started running on the 1st of July. We ran every day through the breakdown. But if we would have run, it would have been, 61 plus 18, 61, 71, 79 days.
So, okay, so all intentions were do the rider, comply with so there's the deadline of September 30th. And that's based on the previous test that was done
Yes, sir.
6 months prior to that?
Yes, sir.
Okay, so comporting with the rule then, basically the timeline. Okay, then you did mention that there's definitely a hard stop, an outage in March, beginning of March, right?
Yes, sir.
And how long will that outage be?
It's scheduled for 30 days. Our last outage went 30 days beyond that, and we could foreseeably see that it would be a 60-day outage to come back online on the 1st of May.
So is that why you put in your petition a July test date for the rider?
Yes, sir.
So that when you come back from the outage, the March outage, then you can run it and then do the rider testing?
Yes, sir. And at that point, there's a lot of gas plants in California, Nevada, and Arizona that are all testing in anticipation of the summer run, which will begin in June and July.
Okay. Let's go back to the repair. I mean, you say it's at the depot in Florida, and you will get a report in a week or so?
By the end of this week, we believe we'll have a first look at it.
They will look at it and give you an idea what kind of repair and how long it'll take?
Yes, sir.
So if we do grant the interim and you come back for the regular variance, you'll have a definite timeline?
I won't have a definite timeline. And the reason I'm saying that is because after the pandemic, the spare part components for all electrical components is very, very long, and you don't know what you need yet. So we'll have a more definitive understanding of how long our repairs will take when I come back in October 25th or so.
And that's what I was getting at, because
Yes, sir.
taking everything into account, they'll tell you, give you an idea, weeks or months.
Yes, sir.
Okay. And so if for whatever reason you cannot get it back online before March, then you will not, you will have to wait until the retrofit is done together with the repairs and
Yes,
then
sir.
come back online and do the test after that.
Yes, sir.
But if you get it done, let's say by the end of the year, hypothetically, in a couple of months, right? Your issue in running the rider then at that time
Will be, as the board asked, it'll be a scheduling issue. As soon as we commission and we know that we can run, we'll schedule a RADA for sometime before the 1st of March. But there's no guarantee that any of those 6 firms will be available. And when I called them this week, they couldn't commit. They said, we need a day that your willing to run, and I don't have a day yet.
Now, but if, I think you also testified that part of the reason why you don't want to do a independent run, independent of Cal ISO demand, is of the cost, right?
Always, that's a concern for us, but it won't be in this scenario. We know that we have to comply with the rules. We know that we're going to spend the $40,000 on gas. We know that we're going to spend the $20,000 on the RADA testing. There's no getting around that. We will have to do it. I won't be happy about it, but I pay taxes as well, and I'm not happy about that.
So hypothetically, you could, I mean, there's no demand. Cal ISO doesn't ask you to run it until what, next year sometime?
No, sir. We are subject to run at any time, and with the way that weather patterns have shifted, if we were online, we could anticipate running now in December, January, and February. That's the unknown for us. We don't know whether they would dispatch us, order us to run and create electricity in January and February if we were online, but we could anticipate that that would be the case.
You have informed Cal ISO of the issue with the repair.
Yes, sir.
So would they be requesting you to run not knowing your?
No, they know, and that's a criminal liability, which we take very seriously, obviously. As soon as we commission, we'll come off of the outage list and we'll be subject to dispatch. And the timeline that council asked me for was, if it's 2 months and I come back online the first week of January and we commission, then we'll have to do as you say. We'll have to try to schedule a RADA as quickly as we can. We know we're going to pay the $40,000 in gas, and we know that we're going to pay the $20,000 in RADA fees. That's just the price of doing business. We'll be unhappy with it, but we'll have to do it.
Okay.
The situation that we're here for today is, if we don't have control of the 6 testing companies, and we don't know whether we would be able to test before the 1st of March when we go into outage. And we could be dispatched for 14 or more, 2 days for testing. We know we're going to burn 12 days of run in the cold months of January and February. We can anticipate that. That's the risk that I'm concerned about. And that's why I filed the petition.
Right. But the other one that is also, you don't know when your unit will be repaired.
That's true.
So you got
Yes.
2 variables.
2 variables.
That, yeah. So you're asking relief. What specifically are you asking for?
We're asking for a variance on our permit to allow us either more than 14 firing days or through the 30th of July to complete our RADA, either or.
Okay. But let me put a caveat then. But if you get the unit back repaired and you can run in January, February, you have no issue running it, the test then, the RADA test.
As long as we can schedule it, we don't have any issue running it.
All right. All right. Okay, I understand better now. Thank you.
Can I make one other point? What we're applying for the variance for is the situation that's out of our control. It's true that we don't want to spend the money to do it, but we don't have any choice. The situation that we're concerned about is if we're forced to run 14 days and we can't schedule RADA. That we don't have any control of. That's why we're in front of the board, is we're looking for relief from that risk, which we think is real. Council doesn't think is very real.
Just to clarify, it's not 14, when you run it, it may be not consecutive days. It could be, and it's as long as
Could be any
within
days.
14 run days, correct?
Yes,
Okay, it's not necessarily consecutive days or anything like that, because you don't know how the request will be made.
correct.
Okay, so anytime 14 operating days, you'll have to schedule tests. It could be several months before you reach the 14
That's
operating
true.
days also.
That's true. And that's happened before in the past,
Okay,
which was council's point.
right. And that's why you got notice of violation
Correct.
in 2019.
Yes,
You
sir.
didn't do the test in that time period. Okay, all right. I think I understand now. Thank you.
Hey, just a couple quick questions. How many employees do you have with this company?
15?
15 employees. So my good friend here is Ms. Verdugo Peralta always asks for a timeline. And I really wish you would have provided one here. Okay, so I'm looking here at the petition. you will undergo a test September 30th? Or just kind of walk us through the timeline. Let me not try to speculate here. Just walk us through the timeline here for the repair or for the testing.
We were scheduled to conduct a RADA test on September 18th to be in compliance with our 6-month rule because our previous tests had been done on the 27th of February. We broke down on the 28th of August. Today, our broken down parts are at the depot. So today's what, the 25th? By the end of this week, we think that we'll have an indication. We're flying one of our employees to Pensacola to look at the facility and try to force them to take us as an important customer. We'll know a timeline sometime at the end of this week. We don't know it now. Typically, the repair takes between 2 and 4 months. So that would be October and November. We try to assemble the gas turbine generator in December, if it was the shorter of the months. And then we would commission sometime probably the first week of January. And that's where the risk for us comes in. We would immediately try to schedule, once we've commissioned and we know we can run, let's say it's the 1st of January, we'll run twice. So of the 14 days council says we've now burned 2 because we have to know that we can run. Then we try to schedule. And as council, or as the board member pointed out, what's out of our control is whether those 6 vendors will be able to accommodate a testing schedule sometime before the 1st of March. Historically, that's been very difficult to do. So we might find ourselves during that window between the 2nd week of January and the 1st of March in a situation where we're dispatched more than 14 or more than the 12 remaining days, and we're in violation of our permit. Council says we should wait until we've fired 11 days and apply to this board for an emergency permit. We think that's an unnecessary risk. And then there's a situation if the timeline is elongated and the repair time is 4 months, we won't come online before, as you said, we go out for our second outage. And so now let's say we're at the beginning of May before we commission again. And we've got 2 days commissioning of the 14 days. So we've got 12 run days. It's very easy that if it's a hot summer, which NOAA says that it's an 80% likelihood it'll be 2 degrees hotter than last summer, 2025, it's very likely that we could run 12 days before we could get a RADA scheduled, because those 6 vendors are going to be very busy as every other gas plant tries to achieve its AQMD obligations.
So you have someone going to Pensacola this week.
Yes, sir.
Okay, I'm almost confident they're not going to go to Pensacola.
Because of the hurricane?
Exactly. So then what happens next?
They wait in the airport until we can go. Our truck is arriving today. We know, during one of our recesses, I got the analysis that it's on site, but you're right. They're saying they can't unload. So I don't know.
So that pushes the timeline back to another week or 2.
Yes, sir.
Because there's work underway at the facility for other individuals around the country. So that could be a month. Who knows?
Yes, sir.
So let's just hypothetically say the district is correct. So what's the risk in waiting until there's some data available and then they can make a proper assessment? Because we'll answer that first and I'll go into the next one.
The risk is that we get into an emergency situation for this group, right? When I called to figure out what kind of variance we were going to look for, we didn't have to schedule this kind of a variance, an interim variance. But when we thought it was going to be a long term, we said, oh, we're going to need a regular variance. And then we don't have 45 days, so we've got to do an interim variance, which is why I'm here today. But what I don't understand is what's better or what's more clear. Why would the AQMD want me to get into more of a risk situation of violating my permit by waiting until January after I'm already, when I'm commissioned, and then I'm being dispatched by the CAISO. The variance permit allows you to grant me a permit now, and there's no, or grant me a variance now, and it eliminates the risk of violating my permit. I don't want to violate my permit. We're trying to be in front of that. So I guess the answer to your question, the simple answer is risk. Why do I want to bear more risk for violating my Title V and reclaim permit by waiting until January?
So let me ask you a question, Madam Clerk. Was this meeting was notified? There was a 10-day notification period on this meeting, right?
Did you say a 10-day?
10 days.
Yes.
Okay, so just to be very clear, sir. So there was a 10-day notification period, and I think Ms. Verdugo Peralta is correct. Perhaps there might be a little confusion here. I believe what the district's council is saying, there is a provision within the Health and Safety Code which allows for an emergency variance, of course, based upon the establishment of good cause, which requires no notice to the public. So I get your perspective, but I guess what I'm struggling with is there's no data. There's no data for us to actually review or substantiate. And perhaps if we were to continue this case until a later date, at least until you're able to review or receive the initial preliminary from Pensacola, I'm just trying to find a happy median here. And perhaps I'm a little struggling because there's nothing for us to really hang our hat on other than the presumption of what could possibly be. Can you kind of add some flavor to what I'm saying, or perhaps?
Yes, sir. So I guess it's an evidentiary question. I'm under oath. I've been running this facility for 5 years. I already have one NOV under my belt where I've been burned in this situation before. My testimony is what I'm counting on to tell you that I feel that I'm at risk of violating my permit. That's it. I don't have anything. Other things are out of my control. So unless you believe my testimony that I'm at risk, then you're gonna have to vote with the council.
Well, first, look, I'll tell you this. I tip my hat to you for coming forward as well as being proactive. And I want to say that for the record. And so I do respect your position. And of course, you're going to get a fair shake here. You know, there's no decisions have been made.
She's pretty formidable.
Well, yeah, true. But of course, she's doing her job, and we're just trying to find a happy path to be able to make everybody happy. Miss Conica Macklin, you got some comments, I believe?
I do. I truly understand and sympathize with your position. But unless I can make that finding, and which is the reason for my questions, I must side with the district. I find this to be a premature matter, and I understand your need to be proactive, but being proactive also means that I need something to substantiate your testimony. It can't just stand alone in the weight of, or stand alone with the weight of what the district has presented. So the questions concerning the scheduling of this hearing are really germane to me because it appears that it's premature and that there isn't sufficient information for me to get to the next step in order to grant what you're requesting today. If this were October and you had more information, I think I could get there easily. But as we sit here today, I cannot. So I'm struggling with what you're providing. And your statement, all I have is my testimony, while it is very valid, very appreciated, I still need other documents to go along with it, to substantiate and to support it. So unless there's anything else, my question is, why are we hearing this today versus it being continued to a later date?
Ma'am, may I ask a question? So let's assume that I come back in January and I've commissioned, so I've burned 2 of my 14 days, and I can anticipate it's a cold winter and we're going to get dispatched by CAISO, but I haven't been dispatched yet. Let's say it's like the 6th of January. I burned 2 of my 14 days, but it's cold and I can anticipate that I'm going to be dispatched. Would I come back then? And what does that schedule give you more than now?
Chair Ali, if I may, just for a clean record, the district objects to the question as a hypothetical and an inappropriate question to the board member, but I completely defer to the board member if you want to answer.
We're going to overrule that.
Thank you.
I think that the hypothetical that you're given assumes a worst case scenario and doesn't necessarily assume the facts that have already been presented. October, to me, seems to be an appropriate time period to consider this, because based on your testimony, that's when you'll have more information. And it's that more information that we need in order to get past the first step or the first hurdle in this. I don't see a need for you to wait all the way until January. I don't think that's ever been proposed. But what I do see is a need for there to be additional information. So I would hope that in the interim, based upon the emails that I've seen, that there would be ongoing communication so that you wouldn't feel that there would be a catch-22 or that you're behind the eight ball. That is not our purpose at all. But I certainly need to have verification of there being a true emergency or there being a true issue here. And right now I don't see that. I see a hypothetical issue.
Mr. Chair.
Ms. Verdugo Prata. And then we'll go to Mr. Balakapalan.
Mr. Munoz, does Cal ISO, are they aware of your situation?
Yes, ma'am.
And what is their response?
Come back up online as quickly as possible.
Okay, and so due to facts beyond your control, for instance, having to wait for the equipment and not knowing when they're going to want to deploy you. I mean, really, you're at a loss right here because you're not able to provide the electricity that they may be asking you to generate and contribute into the grid, correct?
Yes, ma'am.
Okay, so that's a loss there of revenue. The other thing that I see here is that I understand your fear of having another notice of violation as this one, and it's hanging over your head, correct?
Correct.
Okay, so that's where, I agree that we have to find a happy medium because there isn't, as Ms. Conager-Macklin pointed out, that we do need more information, and maybe something from Cal ISO would have helped us get to that point, because I don't know that we, as a total board here, understand the great dilemma that you are in reference to not being able to generate, and you're losing that revenue, and you're also going to have to pay that either $20,000 or $40,000. So that's a large amount of money, and especially between, let's say, if we wait from now until whether it's December or January. But I do agree that there are missing parts here that we maybe cannot come to a conclusion right now. But I do think there needs to be more dialogue between AQMD staff and you, so that there is a better protocol, because I see this happening to you time and time again. And that's the other dilemma that you
Ms.
have.
Verdugo-Peralta, objection. What evidence is in the record that this happens to this facility time and time again? Every facility is
Well,
subject to the same
My
water rules.
experience, Miss
I want to sustain
Manwaring,
Ms. Manwaring's objection. Go ahead, Ms. Verdugo.
my experience in coming from the utility industry, as well as consulting to companies like this, is that they are, because Cal ISO demands, as he said earlier, they don't ask, oh, are you going to be available on Monday? No, they tell you, we want you available. We want you now, or we are going to have 5 days that we're going to want you. They never know. Cal ISO doesn't even know sometimes, because it's too hard to project what the demand is going to be. And as we have seen in recent years, the demand is getting larger and larger and larger. Not only because of population, but also because of technology and the requirement of more electricity and higher quality electricity. That's another issue that we haven't talked about here. These companies have to, as I said before, they have to respond. Otherwise, they're not going to be considered. If they cannot respond, they are put on another list of not being able to contribute into the grid. And that is what they're in business to do. So, you know, I'm not sure what we can do about that at this point, but I think we need to recognize the fact that this company is in a situation that it's going to cost them a lot of money, and they're in the situation of having to wait for the parts to come back. So I don't know what the answer is here.
So I may have a solution. I do want to instruct the witness not to answer. That's Ms. Verdugo-Prouch's comments. The objection was sustained, and so we will indeed move forward therein. What I'm proposing is that we continue this hearing. We continue this hearing until October. Ms. Manwaring, I do want to hear from you because members of the board would like to see additional information as well as data. And so that's what I'm going to proffer to the board to consider. But I do want to hear from both of you. Ms. Manwaring first.
There's absolutely no need to continue this hearing. There is no violation. There is no basis to grant an interim variance. We are on calendar to come back on October 24th on a publicly noticed regular variance. If at that time there's information about commissioning the engine or anticipated call-up days, we may be in a very different position. There's been no notice to the public. There is no violation, and the district recognizes your authority, but we don't think continuing the interim variance hearing is an appropriate solution.
Okay. Mr. Munoz?
We agree with continuance, Mr. Chairman.
Okay, so if we continue the hearing, you're back anyway, October 25th,
Yes, sir.
right? 24th, you're on the agenda.
And that can be done like the gentleman online. Is that correct? For me?
Well, considering some of these complexities, you may want to be, do you live in Los Angeles?
I'll be in Puerto Rico. We're building power plants in Puerto Rico, and I have to be there when they start to dig.
Well, then it would have to be online. But again, it just would make more sense. Do you have a representative who can be present? Just to kind of tag team it with you. They can make sure the documents.
I will see if we can do that. I understand the complexity and what I'm asking.
Okay. No, but listen, we'll accommodate you. I mean,
Okay.
we do want to be fair to everyone. All right, Mr. Alagapalan.
Yeah, we are still in the questioning phase. of
Yes,
the
we are.
witness,
We
so
are.
We're not in the deliberation yet. Mr. Minas, just to be clear, if you don't get, you had scheduled the test on September 18 to come into compliance with the September 30th deadline, the 6-month deadline.
That's correct.
So if if the test is not done by the end of September, are you potentially in violation?
I want to say yes, but council is shaking her head no because she knows that I have 14 firing days before I actually violate.
Well, if you're asking for the extension and there's a caveat on that, if you want to delay. So it's, I'm not talking, if you look at the language in the rule, which was handed to us, the 14 days is the date, the due date for a semi-annual, annual, or may be postponed to within 14 or may be postponed, If you're seeking postponement, yes, from the first refiring, and all that, if the fuel line is disconnected or, open feed lines are maintained. But that's not what you're seeking, though. Are you seeking that?
No, we do not want to disassemble our fuel lines.
So you're not asking for this postponement that is referred to in the rule?
No.
Okay, that's straightforward to me, at least, that you, okay, I don't want to.
No, it's perfect. Ms. Verdugo-Peralta, then we're going to move to closing comments.
Okay, can you get a document, or can you bring even as a witness somebody from Cal ISO?
It is unlikely that anyone from Cal ISO will come to any other body's hearing.
Can you get a letter from them documenting the protocol, the requirement, whether it's, I'm sure that it's written somewhere, but I'd like to see something from Cal ISO because I want to understand how important the demand is, and especially on the deployment. And I'm sure that there's some documents that state that, and maybe we need to see that as well.
There's two components that come to mind. One is the tariff itself that's been approved by the FERC. And then the second one is our generator interconnect agreement with the CAISO. So I will endeavor to find something that essentially says we don't have an option, we have an obligation.
Right.
And that obligation is not civil, it's also criminal.
Right. And you mentioned the Federal Energy Regulatory Commission, which also is part of this. So I think it's important that we see how the pressure that companies like yours are under to provide electricity for the grid and as a public need. I think that's very important.
Yes, ma'am.
All right, so, Ms.
Mr. Chair, can I
Manuel-
ask a question?
go right
as
ahead,
well?
Dr. Abraham.
Yeah, so I was just curious, do y'all have counsel engaged in this conversation or any consultants that are perhaps familiar with these nuances that are coming up? I'm personally confused now throughout this hearing, trying to better understand what the right course is forward. I'm just curious, have y'all engaged, a counselor, for example, to be able to better represent and address some of these issues that are going back and forth? And also, do you all have any consultants that have helped with this as well?
I'm sorry, the last sentence that you said?
He's referencing counsel and consultants. Do you have any lawyers or consultants that can help with this? The delicate nuances appear to be somewhat elusive.
We have a corporate counsel. We have the ability to hire counsel. We choose not to because I understand that this is complex in the way that, for example, Rule 212 and Attachment C are listed. But if I, as an operator, can't understand what these rules are saying, or if I can't comply with them, then that's an issue that I'm not willing to pay someone else to understand for. It's my obligation, and I'm going to understand it. I'm sorry if I come off as a uneducated buffoon with reference these rules, but I'm not going to hire counsel to address this because I just think that the government has to be clear enough for a business to be able to operate. That's my personal philosophy. So the short answer is no.
Okay, so we're up on the lunch hour. I'm just curious, do we want to waive any future witnesses and perhaps we'll just come back on the 21st? If you want to call the witnesses, Ms. Manuel, you have that right. Just wanted to.
The potential issue is to continue over the interim variance?
Well, no, I believe at this point, the board would take action today, and then we would then come back on the 24th as planned.
I don't think you're speaking for the full board, so I think you want to clarify that,
No, I'm clarifying. The board will take action. The board will take action today. Yeah, and whatever that action is what the action is. But we're not going to continue. That was just a thought, and there was some objection to that. And so, of course, we're backing down
It
from.
was a great thought, Mr. Chairman.
Not a problem. All right. So did we want to waive?
Knowing that we will be back here on a regular variance on October 24th, any issues we had with Mr. Munoz's testimony, we can take issue with at that point.
Thank you. Okay, we're going to move to closing comments. Mr. Munoz first.
Again, I don't understand why AQMD wants to force a emergency situation on our predicament. I understand the board's requirement for a more definitive timeline. Thank you.
Ms. McWarren?
There simply is no violation at this point to grant a variance from. Whether or not there will be one to grant a variance from, or at least more certainty as what that likely violation may be, perhaps we'll know when the regular variance comes. I believe Mr. Munoz's recollection of firing days when the NOV was issued in 2019, he's misremembering, and it was more than 5.5 months. His testimony about a sunk cost of $20,000 for a test that's canceled 5 months, that's canceled, I don't think is going to be accurate with the investigation that we do between now and then. And we have some concerns. Ms. Verruga-Peralta, I appreciate your sensitivity towards business, and I recognize your expertise here. But Mr. Munoz was very clear. He wants more than 14 operating days. He wants to defer the test till the end of next peak season. We don't need to grant a variance to do that. The district rule writers have worked very hard over the years to provide multiple off-ramps. He was provided an off-ramp in 2019 that he did not avail himself of over the course of 5.5 months. He has an off-ramp here that he may choose not to avail himself because he doesn't want to disconnect the gas lines. And while that might be his prerogative, I think he should think long and hard about the implications of missing data procedures that may apply or other consequences. But if he chooses not to avail himself of a 14-day extension, I'm going to take issue with finding number 2 as to whether or not it's beyond his reasonable control. But those are conversations that we can have in October when we come back, when things aren't hypothetical, speculative, guessing, have no way to know because there's no timeline. There is absolutely, given that we're coming back for a regular variance, and given the lack of evidence about an existing or likely violation that is beyond his reasonable control, there's no basis to grant the interim variance today.
All right, on deliberation, Dr. Abraham, are you? You go first, sir.
Yeah, definitely concerned about even the response from the petitioner there. I'm not a CPA. I still have to file my taxes. If I do make a mistake and I choose not to engage a specialist or someone that maybe knows the nuances better, I'm still going to be held responsible. And so I am a little worried that I am lost in some of the nuances of the rules that we're dealing with here. And I'm worried that the petitioner also is missing maybe some of the points that have been brought up by the district. I think this could have been handled differently. And given what we have been presented today, I am now finding it very difficult to grant this interim variance.
Mr. Butler-Capelan, sir.
Yes, I do believe I could make the 6 finding to grant the interim variance. And, as indicated, and we didn't hear testimony from the district otherwise, in the petition, they are required to, the semi-annual test is due September 30th, 2024. They scheduled the test for September 18, the all intention to do it before the deadline. However, due to operational problem with the turbine, they couldn't do the test. So they are potentially in violation of that date. Now, whether the district gives a ticket or not, that's not the issue. That's what I'm reading from the petition. That's that prior to September 30, 2024. So the interim variance will give, because it's only good for 90 days. So that will take them over. So that it will cover them until when they come back on for the regular variance, public notice, regular variance. At that point, we will get more information regarding when the unit can be operational, when the repairs will be done, and when they can reschedule the radar test. So I am inclined to, and I can make the other. I think this is a more critical one, whether they're in violation or imminent in violation. And the other 5 findings, I can go through and make them easy now because they're not in operation. There's no emission, so a couple of them will just drop off. So I would I'm happy to make the motion to grant the interim variance, even though we don't have any condition maybe right now, but we can come up craft some conditions, and maybe with the district assistance, until they come back to the regular notice to hearing, and then we can decide then if it merits the granting of the regular variance.
Okay, Verdugo Peralta?
Thank you, Mr. Chair. I happen to agree with Mr. Belagopalan. I think Mr. Munoz came here in good faith to try and work things out with the district, but also to ask for some protection in the interim. But, and that's exactly what this is, an interim variance between now and when the regular variance is going to be heard. He is under a lot of negative risk here. And a risk I understand that I don't think is necessary. If we grant the interim, he's got that protection. And I think they need that protection based on the fact that, as he has said, they are not going to get the equipment on time to do the errata test. So they have that potential of being in violation. I don't understand the comments from Ms. Manwaring that there is no potential violation. And maybe I'm misunderstanding what she said earlier, but I do see a risk here unless we grant the variance.
All right, I'd like to proffer. So you want to put your motion on the floor, Mr. Bellacaplan? Let's see where the motion goes.
Mr. Ali, have you heard briefly?
Question.
Should there be 3 votes to grant the interim variance, the district did prepare conditions, as we always do. Just to advise you, they mirror and track attachment C subparagraph B2C.
Okay.
I'd also want to make sure that it's understood that if Mr. Munoz chooses not to avail himself of the extension, missing data procedures apply as of the date of violation.
Could we get a look at the proposed condition, please? If I make the motion,
Yes, but
because I need to refer to those.
absolutely. I mean, but I want to make clear, I want to make it very clear as we're making the motion that I don't believe that there are 3 votes present. I just want to be very clear. So I'd rather we go ahead and go through the process, but
But perhaps if there's a counter motion, the counter motion should be taken up first.
I have my mic on. There is a
Yes.
counter motion.
yeah, so I can make one and you can make it.
You can go right ahead.
All right, I was going to make the motion in the matter of Enery Holdings, case number 6248-2, facility ID number 186899. I move that we dismiss the petition for an interim variance without prejudice for failure of the board to find good cause to holding a hearing in absence of notice to the public.
I would second that one. Then I will call the question.
Okay, there's a motion on the floor and as well as a second, moved by Ali, second by Connigan Macklin. Any question or discussion on this motion?
And if this motion doesn't pass, then we can move.
Okay.
forward looking at the condition.
All right, we'll go with Dr. Abraham,
Aye.
Ms. Verdugo Peralta,
No.
Mr. Bellacaplan,
No.
Ms. Connigan Macklin.
Yes.
Ali, I votes in the affirmative. The matter is hereby approved 3-2, and we will see you on the 24th of October. This case is hereby dismissed at 12:02 p.m. And we're off the record, Mr. Day.
We are adjourned for today.
Mr. Day, we're off the record, sir. Are we off the record? Oh, okay.